Thank you, Mr. Chairman. Judge Thomas, welcome. As I look at your record, it continues a pattern of the Biden administration of nominating individuals to the bench who have long careers as activists. Throughout the course of this hearing, you have explained some of your prior positions as simply representing a client. But when I look at your career, I don't see that. I see that you are passionately committed to a particular vision of the law. It has ranged from filing briefs in litigation in the state of Texas, defending race-based discrimination in university admissions, to most consistently transgender activism, and I would submit extremism. And this hasn't been one client you had in one case. This has rather been a consistent pattern that extended when you were a lawyer for the state of California, that extended when you were a lawyer for the U.S. Department of Justice, that extended when you were a lawyer for the state of New York. In 3 different jurisdictions, you have been involved in litigation on the extremes of transgender issues. And in particular, you've carved out an expertise for yourself using litigation to force institutions to allow biological males to use restroom facilities and locker facilities that are also used by girls, young girls, that are used by women. And this has been a pattern. When you were a lawyer for the state of California, you filed a lawsuit against Crunch Fitness, a gym, for not moving quickly enough to allow a biological male to use the women's locker room. When you were a lawyer for the state of New York, you filed briefs against the state of Texas, against the state of North Carolina, again, advocating for biological males to use girls' and women's restrooms. And, you know, the thing I find troubling about these arguments is it seems the women and girls never have any rights. That the girls that would like to shower next to someone who is not a biological male, who would like some privacy, their rights never seem to matter. And your pattern, it's not a single case. It is across 3 jurisdictions over and over again. In the Texas case, the brief you filed said, quote, "There is no data or tangible evidence in support of the claim that allowing people to use bathrooms corresponding with their gender identity will lead to increased violence or crime in restrooms." Do you stand by that statement?
Thank you for the question, Senator Cruz. Again, as an advocate, you advocate for the positions of your client. I haven't been an advocate for 3 years. I've been a judge. And when
3 years is not very long. And my question is simple. Do you stand by that statement?
Senator Cruz, it would not be appropriate or consistent with my ethical duties to my former clients to comment on my personal views about any case that I worked on. What my duty was to advocate zealously for my clients. I have set aside the advocacy role, and I now occupy a judicial role where what you're
Judge, your brief also contended, quote, "In states where anti-discrimination protections are already the law, the predicted safety harm has never materialized." You made a bold, aggressive, factual statement, by the way. In North Carolina, you said safety concerns were, quote, "unfounded." You were an aggressive advocate, an activist advocate. And I believe the statements that you represented to the court, and those are statements that you're making as an officer of the court. I believe they were false, and they are extreme. You testified to this committee that you were not aware of what happened in Loudoun County until this morning. I find that remarkable for someone who has spent years as one of the leading activists for allowing transgender biological men to use girls' restrooms and women's restrooms. And Loudoun County Scott Smith, who's the parent of a 14-year-old girl, alleged the Loudoun County School Board covered up the sexual assault by a gender-fluid individual against his 9th grade daughter who entered the girls' bathroom in a skirt. And this individual was charged with 2 counts of forcible sodomy, 1 count of anal sodomy, and 1 count of forcible fellatio. The school district covered it up. They released this sexual predator, and the predator committed sexual assault again, twice. Why did you represent to the court that concerns about violent sexual predators committing violent crimes against young girls are unfounded and speculative? Why did you represent that to the court?
Thank you for the question. I advocated on behalf of my clients based upon the data that we had at the time, and I zealously did so in those cases and in every other case that I handled.
Were you right?
Senator Cruz, it would not be appropriate for me to comment on the merits of any personal views regarding litigation that I handled on behalf of my clients.
Well, these little girls who were
Senator
sexually
Cruz,
assaulted
let her respond.
will have a
Let's
very
let Ms.
different
respond.
assessment.
Senator Cruz,
These
let
little
Ms.
girls
Thomas
who were
respond.
assaulted. Thank you for your
Time is
views,
up.
but
You're past time. Let's afford Ms. Thomas an opportunity
she
to
is
respond to your
perfectly
question.
welcome to respond. But as I said, the little girls who were raped in
Thomas.
Loudoun County would have a very different assessment of whether this threat and danger is speculative or not, and you're more than welcome to respond.
Thank you. I will just conclude by saying again that I understand the difference between being an advocate and being a judge. I am a judge now, and what I'm guided by is the record before me and the law, and that is what I do now, and it's what I'll continue to do if confirmed.
Thank you.
Thank you, Chairman. Director, I guess this is our first meeting. I hear you're from Georgia, my home state. Regarding the raid on Mar-a-Lago last summer, the Justice Department filed an application for a search and seizure warrant of Mar-a-Lago citing probable cause. That additional presidential records and records containing classified information remained in various parts of the residence. The FBI executed this search and raided Mar-a-Lago and has been investigating President Trump for alleged improper handling of classified information and presidential records ever since. Director Wray, are you familiar with the Presidential Records Act?
I mean, only in the most general sense. I'm not a subject matter expert, nor am I currently practicing as a lawyer.
Only in the most general of sense. Okay, the Presidential Records Act, 44 U.S.C. 2201, is the controlling statute for presidential records. And I have a copy of it right here if you'd like to see it. Was the Presidential Records Act referenced in the request for a warrant?
I would just refer you to the warrant.
I'm asking you a question.
Yeah, I don't have the warrant in front of me, so I can't, sitting here right now, tell you exactly which statutes were referenced in the warrant from August.
I mean, this is one of the most historic raids and warrants ever done in this country. Never, ever done before, and you don't know what the warrant says.
I didn't say I didn't know what the warrant says. I don't have the specific details in front of me of exactly which statutory code references are in the warrant.
Okay. Are there any criminal penalties attached to the Presidential Records Act?
Well, again, I think that's a legal question, but my general recollection is not directly, but I'm not certain of that.
You're correct. There are no criminal penalties attached to the Presidential Records Act. Under the Presidential Records Act, the President is allowed to have all his records from his time as President. Is that correct?
Well, again, now you're asking me for a legal opinion about the scope of the Presidential Records Act, and I would refer you to the special counsel conducting the investigation on that.
All right. According to statute, presidential records are defined as any document created or received by the President or his staff, for your information. It does not exclude classified documents either. And that's right from the U.S. Code, right here. So President Trump had complete authority to unilaterally declassify documents, correct?
Again, now you're asking me for a legal question, and you're asking me for a legal question in relation to an ongoing investigation being led by special counsel. So I certainly understand why you're asking the question. I respect that, but it's not something that I can answer
Okay.
appropriately.
It's my understanding the president has that authority, the vice president and a senator does not. Is that correct?
Same answer.
All right. According to the Presidential Records Act, personal records are excluded from the Act's preservation requirements. Are you familiar with the 2001 sock drawer case in which a plaintiff petitioned the court to consider whether tapes found located in President Clinton's sock drawer, many containing conversations with foreign leaders and therefore born classified, were to be considered personal records or official records? Are you familiar with that case at all? I mean, you've been in the Department of Justice for a very long time.
I can't recall a case involving a sock drawer. I know there was a case involving the former National Security Advisor who had served in the Clinton administration involving some classified documents, but I'm not sure if that's what you're referring to.
This is dealing with President Clinton himself.
Yeah, at least sitting here right now, I don't immediately recognize it. Maybe if I saw something, it would come back to me.
Okay. Judge Amy Jackson's opinion in that case, citing 44 U.S.C. 2203 Bravo, Judge Jackson ruled that in the court's view, under the statutory scheme established by the Presidential Records Act, the decision to segregate personal materials from presidential records is made by the president during the president's term and in his sole discretion. Considering Judge Jackson's ruling, why do you believe the White House counsel, Jonathan Sue, with President Biden's approval, waived President Trump's executive privilege when, according to the Presidential Records Act, only President Trump had the authority to determine presidential versus personal records?
So, respectfully, there's a couple things that go to your question. One is, again, you're asking for a legal opinion, and I'm very careful as FBI director to stay in my lane, and the legal questions should be referred to the Justice Department. But second, it sounds like in this particular instance, you're asking me about what somebody else was thinking when they did or didn't waive the privilege, and I can't speak for them.
All right. What did it cost for the FBI to pursue this case and execute this raid?
I don't have a cost figure for you.
Can you provide that for me?
I can see if there's information we can provide you. I'll certainly have my staff follow up with you. I don't know if there's information we can provide, but I'll look into it.
All right. Thank you, and I
gửi đi mấy lần đợi hồi âm chưa thấy. Anh ơi nhớ rằng đây còn có em đêm ngày hằng thương nhớ vơi đầy. Ngày đi người đã hứa toàn những lời chan chứa còn hơn gió hơn mưa. Một tuần một lần cứ kể nghe chuyện sương gió, kể nghe chuyện ước mơ. Nhưng anh vắng hồi thư hay là anh hững hờ hoặc là anh không nhớ. Em đâu khác người xưa ngày lẫn đêm mong chờ tình yêu nói sao vừa. Từ lâu đành xa vắng đời trăm ngàn cay đắng, hỏi anh biết hay chăng. Chỉ cần một hồi âm là em mừng vui lắm, cớ sao anh phụ lòng. người thành đá ngàn kiếp yêu thương chồng. Ngày nay em nào thấy lòng chân thành của tình thế nhân, tìm đâu trong tình yêu được bền lâu để kiếp sau không sầu. Em mơ ước làm sao cho trọn mối duyên đầu, đẹp lòng anh yêu dấu. Xưa chức nữ chàng ngưu từng đắng cay dại dầu, chờ ô thước bắc cầu. Còn anh từ xa cách làm em hơn em trách, hỏi anh có hay không. Mỏi mòn đợi hồi âm, thêm hoa đành lẻ bóng, nhớ thương anh ngập lòng. Năm tháng hoài mong thư gửi đi mấy lần, đợi hồi âm chưa thấy. Anh ơi nhớ rằng đây còn có em đêm ngày, hằng thương nhớ vơi đầy. Ngày đi người đã hứa toàn những lời chan chứa, còn hơn gió hơn mưa. Một tuần một lần thư kể nghe chuyện sương gió, kể nghe chuyện ước mơ. Nhưng anh vắng hồi thư, hay là anh hững hờ, hoặc là anh không nhớ. Em đâu khác người xưa, ngày lẫn đêm mong chờ, tình yêu nói sao vừa. Từ lâu đành xa vắng, đời trăm ngàn cay đắng, hỏi anh biết hay chăng. Chỉ cần một hồi âm là em mừng vui lắm, cớ sao anh phụ lòng. Ngày xưa anh còn nhớ nàng Tô Thị bỗng con ngóng trông. Thời gian đã hoài công, người thành đá ngàn kiếp yêu thương chồng. Ngày nay em nào thấy lòng chân thành của tình thế nhân, tìm đâu trong tình yêu được bền lâu để kiếp sau không sầu. Em mơ ước làm sao cho trọn mối duyên đầu, đẹp lòng anh yêu dấu. Xưa chức nữ chàng ngưu từng đắng cay dại dầu, chờ ô thước bắc cầu. Còn anh từ xa cách làm em hơn em trách, hỏi anh có hay không. Mỏi mòn đời hồi âm, thêm hoa đành lẻ bóng, nhớ thương anh ngập lòng. mỏi mòn đợi hồi âm thêm hoa đành lẻ bóng nhớ thương anh ngập lòng. Mỏi mòn đợi hồi âm thêm hoa đành lẻ bóng nhớ thương anh ngập